Okay, Rule 3.8, Special Responsibilities of Prosecutor. I was telling you this is a shortcut to exoneration if you have exculpatory evidence, and if you use the right laws, you don't even need exculpatory evidence. The reason I'm using the ABA Model Rules of Professional Conduct is because a lot of states took it out. And that's a violation of the rule of professional conduct. Okay, because in the preamble it says they must do what's in the public interest to maintain the public trust. The public trust, part of the public trust is the legal system, all lawyers and judges. Okay, so everybody's required to abide by, enforce, and report any violations. Okay, now, Rule 3.8, Special Responsibilities of a Prosecutor, is the extra rule for criminal court. All the rules apply to all lawyers, except for this one. This is a special one for criminal court. Okay, a lot of lawyers have denied that in the past, and we've had confrontations. Okay, so I'm using Rule 3. So if you don't see it in your state, when you look up the rules of professional conduct, you're going to have to refer to this, okay, because this is mandated as far as effective assistance of counsel goes in the Sixth Amendment, okay, of the U.S. Constitution. Any law repugnant to the Constitution is void, so taking out this rule is repugnant to the U.S. Constitution based on effective assistance counsel, fair trial, okay, and due process. Okay, so them taking it out, that's multiple constitutional violations, okay, and it's also violation. If you read the preamble in the Rule of Professional Conduct, it says that was in the interest of the bar. They have to do what's in the interest of the public, not in the interest of the bar or parochial interest. Prosecutors in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. That's why I went to court so many years and tried to help people to get a probable cause hearing. You won't get a probable cause hearing if you don't demand it, okay? If you get a probable cause hearing, they find out there was no probable cause for arrest, the case gets tossed out that day. And the reason they don't like to do that is because that means the cop made a false arrest, and that's just legal harassment, so that should go against them, not you. But in my belief, that's the main reason for not offering you a probable cause hearing. You won't get it unless you demand it, just like you won't get a quick and speedy trial if you don't demand it. And that's your constitutional right. B, make reasonable efforts to ensure that the accused has been advised of the right to and the procedure for obtaining counsel and has been given reasonable opportunity to obtain counsel. Okay, so they should make it clear. If you go by the preamble, it's their responsibility to tell you what I'm telling you, but they're not doing it. Okay, so obtaining counsel has been given reasonable opportunity. Okay, but anyways, effective assistance to counsel, this is part of it. Okay. C, not to seek or obtain from an unrepresented accused a waiver of important pretrial rights, such as a right to a preliminary hearing. Sometimes when you get arrested and you ask for a lawyer, they will bring in an assistant state's attorney to talk to you and try to get you to confess. Or in case you sign a confession, they beat you into signing a confession. Well, that's who will bring in the assistant state's attorney. They won't bring in an attorney to represent you. That happened to me, and they got mad because I wouldn't sign. So if you want effective assistant counsel, you're going to need to learn the rules of professional conduct, because you're not going to get effective assistance of counsel unless you have reasonable knowledge to make an informed decision to give informed consent. You'll never, if you don't know that, if you don't read the rules of professional conduct, in the Code of Judicial Conduct, you'll never get a fair trial. You have to demand this to happen, otherwise it won't. Make timely disclosure to defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense, and or in connection with sentencing disclose to the defense and to the tribunal all unprivileged mitigating information known to the prosecutor, except when the prosecutor is relieved from this responsibility by a protective order of the tribunal. And it's rare that they'll do that. So, I mean, most of the cases that are being overturned on wrongful conviction is because of failure to expose exonerating evidence. They're in it for the win, not to see that justice is served, and that's the opposite of what being a state's attorney is all about. E. Not subpoena a lawyer in a grand jury or other criminal proceedings to present evidence about a past or present client unless the prosecutor reasonably believes the information sought is not protected from disclosure by any applicable privilege. The evidence sought is essential to the successful completion of an ongoing investigation or prosecution, and or there is other feasible alternative to obtain the information. F. For the statements that are necessary to inform the public of the nature of the extent of the prosecutor's action and serve legitimate law enforcement purposes, refrain from making extrajudicial statements that have a substantial likelihood highlighting public condemnation of the accused, and exercise reasonable care to prevent investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor in a criminal case from making an extrajudicial statement that the prosecutor would be prohibited from making under Rule 3.6 of this rule. G. When the prosecutor knows of new and credible material evidence creating reasonable likelihood that a convicted defendant did not commit an offense of which that defendant was convicted, the prosecutor shall, 1, promptly disclose that evidence to an appropriate court or authority, and 2, if the conviction was obtained in the prosecutor's jurisdiction, I. promptly disclose that evidence to the defendant unless a court authorizes delays, and I. undertake further investigation to make reasonable efforts to cause an investigation, determine whether the defendant was convicted of the offense that the defendant did not commit. H. When the prosecutor knows of clear and convincing evidence establishing that a defendant in the prosecutor's jurisdiction was convicted of an offense the defendant did not commit, the prosecutor shall seek to remedy the conviction. Okay, a lot of people, when I read this to them, they say I sound really good, and I make it sound simple. But I just quote the law. It's just that when you listen to attorneys, they use a language that you won't understand and complicate things. I've had lawyers say I oversimplify the law. I just quote it. I just read it to you, okay? And that's all I did. So a gentleman asked me if I knew of a lawyer that would help him do this. All lawyers know this is the law. So nobody's going to really help you do this. So if you have exculpatory evidence and you can prove your innocence or somebody else's innocence, just gather a whole bunch of people, preacher, pastor, the congregation, ma, pa, your sisters, your brothers, whoever you can. Go over everything with them. Go over with the rules of professional conduct and the Code of Judicial Conduct and all the violations there were to procure this wrongful conviction. Okay, and always remember, use the letter of the law. The letter of the law is a simple mandate interpreting the law. What is written must be whatever is written must be done word for word to the letter. Okay, it's a simple law, the letter of the law. So whatever is written, that's what you see is what you get. Nobody needs to interpret that to you. The letter of the law was created so that way we all read, hear, see, and say the same thing. End of story. Okay, so this is a shortcut to exoneration. I've met and seen a lot of people out there seeking lawyers, trying to overturn a wrongful conviction based on, exculpatory evidence. The Supreme Court had a negative reaction to it, and I think possibly it's because they were a little upset that your state's attorney didn't do their job. But maybe they should have told you to take it back to your state's attorney and have them do it. Oh, they have no excuse, though. They should have told you that. It's what I call a conspiracy to deprive rights under the color of law. It's a legal term. Look it up. It's on the net. Thank you. Have a good night. I hope I made this easier for you to understand the law.